Hello, everyone, and welcome back to one more session on In Confidence with Dr. Reddy, promoted by Address, which is a real time dispute resolution environment. Today, one of our panelists is Mr. Dhruv Suri, who has an LLB and an LLM from USA. He's practicing in Delhi, mostly in the High Court, I guess, and he's associated with the firm PSA. With that introduction, let's bring in our panelist. Welcome, Mr. Dhruv.
Thank you
And
so much.
before we get started, just briefly, I think the topic for today would be Section 11, right? So let's not get into too technicalities. At the same time, let's not simplify it to such an extent that it loses its charm. With that, there are multiple stories in the court, outside the court, and even in front of the arbitrator. Section 11, as we all know, is for appointment of an arbitrator by a court or an arbitral institute. For the time being, let us forget arbitral institutes in this session and say that there is only the parties who can appoint the arbitrator, or if that fails, the court will appoint arbitrator. So these are the only two scenarios which we will limit ourselves to. And then post appointment, there could be challenge to arbitrator, but let's not get into section 16 into too much detail. Let's just touch upon some experiences that we had after an arbitrator was appointed, just briefly. So having said this, I would open the floor to you and say, briefly, can you tell us any specific example about Section 11 that you have encountered, which would be interesting? Please.
Sure, thank you. Thank you. So Section 11 is something that I feel like any practicing arbitrator would perhaps encounter a lot more frequently than they would like, because invariably you have to approach court because parties don't agree on the appointment of an arbitrator. You end up approaching court. But some very interesting questions come up typically because the extent to which the court needs to intervene when appointment has to take place. Should the court actually start adjudicating on whether a valid arbitration agreement exists, whether there is privity of contract between the two parties, or more, if the case may be, should the court get into whether the dispute in itself is arbitrable and sort of give a finding on that at a Section 11 stage? Or should the court, in essence, follow the principle of competence, which is the essence of arbitration laws across the world, and say that, look, our job is to essentially give a view whether there is a prima facie view of whether there is an arbitration agreement. And once we do that, please go before the arbitrator and adjudicate and, let him or her hear what your grievances are. And I think often this line is very thin of how much the court should interfere. So I'll give you an example of what we recently encountered. Was a situation where a Section 11 was filed. We did not appear in that Section 11 proceeding, even though notice was served upon us. And a sole arbitrator was appointed. By court. The sole arbitrator was appointed by court. So, of course, statement of claim was filed, notice was issued upon us to file a statement of defense, and we were asked to deposit the fees. And at that point of time, we realized when we started looking at the documents that there is no valid arbitration agreement in itself. And the issue that came up was, now that this arbitrator has been appointed by court in a Section 11 proceeding, with adequate opportunity given to me to come and be represented in that Section 11 proceeding, and I chose not to. Can now I question whether the arbitration agreement is valid at this stage? Or should the arbitration now continue and my sole remedy lies in a Section 34? And then, of course, the issue was whether the finding of the court when the arbitrator was appointed is only a prima facie finding, or is it a finding which is binding on the arbitrator?
Yes, these types of things are always there. As we say, we are litigating so that we can enter a forum where we don't need to litigate.
Yeah, absolutely. Absolutely. That's actually very well put.
So that's there. But all matters aside, there are several case laws. In fact, obviously, you know them, where courts have looked at limitation and said that these claims are long dead claims. And that's the terminology used by the courts. Dead claims, long dead, not just dead, but long dead. So there the court struck down the arbitration and saying that the claims cannot be entertained because of limitation. To that extent, courts have said that there will be two or three things done. One, the court can look into the limitation, court may look into the limitation, or leave it for the arbitrator to look into limitation. So those are certain aspects where I think even today courts have a duty. In fact, I have come across an ex parte decision where the other party, right, like you said, did not appear in the court, but the court looked at the claims and said these are long and dead claims. We are not going to appoint an arbitrator and dismiss the application.
Very interesting. So if I was to just play devil's advocate with you over here and ask you that limitation is a question of law and fact,
Yes.
right? It's never a straightforward question of just law. Given that it's a question of law and fact, would you then say that at least it should have been referred to the arbitrator for the arbitrator to have adjudicated whether limitation has lapsed or not? Or do you think that at that stage, it is okay for the court to get that deep into the merits of that one issue? Because again, to evaluate whether limitation has lapsed or not, you will get into correspondences and whether there was any admission of debt at which extended limitation, etc., etc. So right, so there are factual and legal issues that come up. Who should decide that?
Yeah, see, that is why I use the term long dead claims. So where the claims are what you are saying, probably within limitation or probably outside limitation, then the courts will not get into that because it's now not a simple question of the law. Now the court has to get into all the facts and the law. So there the courts are very clear and they're saying let the arbitrator decide. But where the claims are so clearly and without getting into facts, just by looking at the basic cause of action, the court have realized that it's a dead claim, long dead claim. Courts are striking it down. So at least to that extent, I'm happy. Because if it's somebody comes back to me after 10 years or 20 years and says, I have a case, let's go and adjudicate. Why would I want to waste my time in a court or in arbitration? But some cases, yes, if you can, see, this is where it gets interesting. What is it that a party has to submit to the court? And if you see the standard applications, we always write the limitation, that the claims are within the limitation. But it's not just a statement. We have to provide when the cause of action arose. And once we do that, courts have said clever drafting and they have said we are not going to entertain that. So interesting cases here and there, but mostly, as you rightly said, courts are not getting too much into the details. And nowadays, at least, since the environment has changed in terms of arbitration, courts are letting the arbitrator decide all the matters. But occasionally, these kind of things are happening. Now, having said this, I want to ask you a question. What happens if an arbitrator is appointed, just like your case, not necessarily that particular case, but the arbitrator doesn't have jurisdiction or there's no valid arbitration clause? Do I need to go through the entire process of 1.5 years before I challenge him at 34? What do you think?
Excellent question. So one is the first level where you get to contest that is at a section 11 stage, where you will go and say that, look, there is no a valid arbitration agreement, the dispute in itself is not arbitrable. And you also have to see whether the requirements of section 7 are met. What if the contract in itself is not valid? Then an arbitration clause, which is either in the contract itself or is an independent agreement. So if it's in the contract in itself, then the contract first has to be a lawful contract for that arbitration clause also to exist. So therefore, it has to first meet that threshold. Who decides that? So in my view, that's something the court should look into, for the simple reason that as a party, if I have to then go before the tribunal, I actually, in an arbitration, I have to then incur fee from my own pocket. And if I don't, then either there is prejudice against me, or if there is an institute that's sort of governing that arbitration, they will not even accept an application from me till the time I don't deposit the fee. So there is a cost burden on me for no reason, when there is no valid arbitrable claim. And sometimes the disputed amount is much, is significantly less. But imagine if it runs into like hundreds of crores. At that point of time, the arbitrator fee also that I have to pay upfront could be quite significant for an issue which is perhaps not arbitrable to begin with. But coming to your question, if at all the issue, so first is, like I said, at a section 11 stage. But let's assume I did get a chance to raise it over there. Then as per section, I can move an application under section 16 before the arbitrator and contest his jurisdiction on the ground that there is no valid arbitration agreement. And I can do that at any stage. So what the law also says is that I can file that application at any point of time before a statement of defense is filed. So anytime prior to that, I can go and say that, look, I don't think the arbitration agreement is valid and you need to adjudicate upon this. And the settled principle, the settled jurisprudence of section 16 also is that when such a objection is taken, it needs to be adjudicated at the earliest. Because this is not an issue that can sort of keep, you can keep pending till the end of the arbitration. So you have to adjudicate upon that. And the underlying premise is that the finding of the court to appoint that arbitrator is a prima facie finding. And this interpretation has only come post the 2015 amendments. Because prior to that, whatever Supreme Court judgments you would come across, which predate the 2015 amendments, they would mostly say that it is the duty of the court to evaluate whether there is a valid arbitration agreement or not. So once the court has evaluated, then that's binding upon the arbitrator. And this is exactly what was questioned. I think it was a 246 Law Commission report, which then subsequently led to the 2015 amendments. At that point of time, this was the very issue that was discussed of how much should the courts intervene. And if we are asking the courts to finally appoint an arbitrator or conclude that there is an arbitration agreement on the basis of which an arbitrator is being appointed, that should only constitute a prima facie view, which should be contestable.
But when it comes to the point, I just have about the fees, I have a quick point there that recently also, in fact, last week, I believe, I read a judgment where the arbitrator did not consider certain documents of the respondent because the respondent did not pay the fees. And the court set aside the award. And in fact, when I sit as an arbitrator and this type of question arises, or where I am a claimant or respondent and this situation arises, I submit only one thing, that if I have a counterclaims, then I'll pay my fees. If I am there only to defend myself, I should not be forced to pay my fees. Think about it this way. Let's forget arbitration and you're going to court. You're going, you need to pay the court fees, right? As an applicant or a petitioner there, you would be filing the court fees. I coming there as a defendant would not be paying any fees. The same principle we can apply in arbitration, and that is not prejudicial. But psychologically, the arbitrator feels that this guy has paid me, the other guy has not paid. So that's the situation there.
Absolutely. And I mean, look, there are always two sides to the coin, right?
Yes.
So one school of thought would be that if the parties consciously agreed to an arbitration agreement or an arbitration clause, then you knew at the time of executing that arbitration agreement that should a dispute escalate into an arbitration, then there is a process that is prescribed, institutional or under the Arbitration Act. There is a schedule of fee that you have to pay to the arbitrator. So whether then you are the claimant or whether you are the respondent, it doesn't matter, because you knew that beforehand at the time of entering into the contract that even if you were to get sued, you would still have to pay that money, because that's how the Arbitration Act in itself is structured in terms of the schedule of fee as well.
Let me just put a wrench in the machinery. What if I had entered into this arbitration agreement before the 2015 amendment, when the Schedule 4 was not existing? And then I invoked the dispute, let's say in 2016. Because when I entered into arbitration, I did not know that I had to pay half the fees. So these are legislative changes which sometimes bring in surprises to what we had contemplated. So it's the prevailing law that exists that we need to adopt, but not the one that was existing on the day we signed the contract.
Absolutely, absolutely. And I think this issue has already been settled when the 2015 amendments also came, that they will not be applicable retrospectively, but essentially apply prospectively. And you can't interpret them to the prejudice of one party.
So these are
I
interesting questions, but I would like to just ask you, maybe can you share one or two more examples about Section 11 that could be useful for others?
Yeah, sure, sure. So I think the one issue that I perhaps I started off talking about was an instance where there was a Section 11 filed against us. We did not appear, and while an opportunity was given to us to be represented, the tribunal was constituted, and we, for the first time before the tribunal, took the plea that there is no valid arbitration agreement. And then I think the councils extensively relied upon multiple case law, where if the court has appointed an arbitrator, and I was given, because there are two principles that come in. There's also principles of estoppel and acquiescence, that the fact that I had been given an opportunity and I chose not to appear in that Section 11 proceeding, and the court has now appointed an arbitrator, because psychologically, even for the arbitrators, when their mandate comes from court, it's a very different way that they sort of perceive that, where they say that, look, the court has appointed me. I can now question the jurisdiction of that court that appointed me to say whether that my appointment is wrong. So, right. So there is that sort of thought process that also plays out. But I think the law on that part is quite crystal clear today. Thanks to judgments that have come, there have been instances where the court has had to over intervene as well. But I think fundamentally the law is settled that if you raise that plea that the arbitrator does not have jurisdiction anytime before filing the statement of defense, regardless of whether you were before the Section 11 court or not. So the Section 11 court can also hear that defense of yours and say, where you say, but your lordship, there is no valid arbitration agreement. And the court then says, I'm sorry, I am appointing an arbitrator. Even then, you have a remedy before the arbitrator to file an application, challenge his jurisdiction. Of course, you will say that either the arbitration agreement is void, or the contract is void, or the arbitration agreement got superseded, or there is no privity or limitation, or whatever the ground may be. And the arbitrator is at that point of time bound to hear you at that point. And so the incorporation, so let me also take a step back. Section 11(6)(a) was introduced after the 2015 amendments. Now, it's also been repealed after the 2019 amendments, but that provision which repeals it has not yet been notified. So what the courts are doing, and then there's a host of judgments now, Supreme Court, 3-judge bench, where they have essentially debated time and again of how much the courts need to interfere and be involved. And I think the consistent stand that has been taken is that, look, if the issue in itself is not arbitrable, or if there is no privity, then those are findings that the court is allowed to give, because they don't want to make it inconvenient for a party. But on the issue of an arbitration agreement, the view that a court gives is merely a prima facie view. And I think that's the part which arbitrators also need to understand. So a lot of the young arbitrators perhaps have a little bit of a difficulty with this, because sometimes it's psychological, right? Because there is a very senior judge who's appointed you. You are in your late 30s, early 40s, a young upcoming arbitrator. You probably don't want to now suddenly say that the judge got it wrong. But the issue is not that the judge got it wrong. The judge's view is only a prima facie view, which is what the law also acknowledges.
Sometimes I feel personally that even in arbitration, we need to have a debate with the arbitrator. Not necessarily that whatever debate we win, the arbitrator should record as a mediation agreement kind of situation. But I feel what you just said, some of the arbitrators, some, not all, some of the arbitrators don't have the necessary knowledge in certain aspects. So it may not hurt if we have a debate with them, with both the parties, one saying this, one saying the other, and then let the arbitrator decide what is better. At least we are educating the arbitrator.
Absolutely. And I think sometimes you come across exceptional arbitrators who will acknowledge that they perhaps don't have subject matter expertise, but their willingness to dive deep into law, to dive deep into, your own submissions that you're trying to make. Because, I mean, at the end of the day, our job as counsels is always to assist the court, assist the tribunal. Of course, you're trying to defend your client, but nobody's going to, or nobody should come and say the wrong law, right? Like, you cannot misguide the person who's supposed to adjudicate upon an issue. So, and a lot of arbitrators appreciate that. I mean, I've been in arbitrations where I know that the arbitrator is fairly young, um, and and they are keen to hear, keen to explore. And sometimes the arbitrator comes back and says, "Look, I have pulled out these 3 judgments, and I'd like to sort of discuss and see how they are relevant or not relevant in this case." And we've had an engagement. It's a little bit off the record also, before and after the proceeding, but there is that interest in trying to understand what the jurisprudence says, which is, in my view, the biggest advantage of an arbitration, right? You can't do that in court. You can't have that kind of an honest conversation in court with a judge, partly because there's no time, even if the judge wants to. But the biggest benefit of arbitrations is that you get that exclusive time with somebody who's going to adjudicate upon your issue exactly in the same manner that a judge has to, which is to get it right? So, and there, when you get to engage in a manner that you perhaps don't get to before court, I think that's a big advantage, for both parties.
Now, we have reached the end of our time. So, in the concluding remarks, I want to ask you a question. Which do you think is the better, a sole arbitrator or a three-member?
Oh, this is the most contentious question, and I wish I would have, or I wish I have an answer one way or the other. My advice always is that a lot depends upon the claim amount, and that's usually a how you end up deciding how much you want to spend on arbitrators, and in terms of arbitrators fee. But I think regardless of whether it's a sole arbitrator or whether it's a 3-member tribunal, the effort that goes into identifying and selecting an arbitrator should never be undermined. I think it's not, I mean, with courts, you don't have that in your hand. With arbitrations, you do. And whenever we've done an arbitration where there's a lot at stake, and depending on who the other party is, just understanding in the arbitrators that you're nominating, and sort of looking into their past, their practice, understanding their own background in terms of the kind of dispute that there is. I think just doing that research is so critical, which I think a lot of clients don't understand. And we as counsels then have to guide them and say that, look, don't just give names. Don't just because you had experience with somebody in the past, don't just give names. Allow us to do a little bit of research on what names to propose, because a good arbitrator can actually really assist in making sure the proceedings are seamless. And so that's something that I think, if somebody was to ask me that in your career, what is the one thing in this arbitration space that you've learned, it's if you have a good arbitrator who understands procedure, who's ready to adopt perhaps today technology, it makes a big difference when you're in the middle of those proceedings.
Okay, so I have not received a straight answer, but I guess that's the way law is. So, with that, I thank you for your time. This was a wonderful session, and we'll catch up some other time with probably one more interesting topic.
Most certainly, Dr. Reddy. Thank you. Such a pleasure.
Thank you.